Jack Smith submits his appellate response, and we're going to go through it, and he's really begging the D.C. Circuit Court of Appeals to keep the gag order in place. This gag order is the one that Judge Chutkan slapped upon Trump and said that he can't call the deranged thugs in Jack Smith's office deranged thugs, and he can't even comment on any reasonably foreseeable witnesses who are going to be involved in the case. We know that reasonably foreseeable witnesses might be hundreds, if not thousands of people. And so Trump's free speech rights are now coming to a head against the government and Judge Chutkan's so-called safe courtroom practices, according to a local rule. And Trump has already submitted his appeal, and now Jack Smith is responding. And so this issue might very well end up at the Supreme Court. So we're going to go through Jack Smith's response on this. And one of the first things that's most interesting about this is that Jack Smith admits that Donald Trump has not even been charged with insurrection yet, even though he's essentially calling him an insurrectionist. And so let's go through it. It's a 67-pager. We'll see who wrote it. We got oral arguments scheduled, in this case, November 20th, 2023, and we'll be covering that in detail. They might even be live streamed or audio streamed, so we might have some good segments from it. So be sure that you are subscribed to follow along with this. But this is Jack Smith, along with Molly and the rest of them, signing off on this answering brief for the United States government filed in the United States District Court of Appeals for the District of Columbia. Here is what they tell us right away. He says, the issue is, of course, is whether the gag order is allowed. But this is the background. He says, Your Honors, at the Court of Appeals, this is Jack Smith speaking, this case stems from Trump's criminal efforts to overturn the results of the 2020 election and prevent the lawful transfer of power to his successor. Now, they give us a quick background here. On August 1st, a grand jury charged him with 4 counts. Count 1, conspiracy to defraud the United States. Great. Counts 2 and 3 charged with conspiracy and substantive violations of 15C2, which is going to be also at the Supreme Court, for corruptly obstructing the certification of the presidential election results on January 6th, right? Literally, for obstruction on January 6th. And then count 4 charges a conspiracy to violate one or more persons' constitutional right to vote. Conspiracy against rights. Got it. Now, the one thing you'll notice, and Jack Smith admits right here, he says, although the indictment does not charge Trump with incitement to insurrection, which you could charge him with under 18 U.S. Code 2383, the indictment squarely alleges that he is responsible for the events of January 6, where they say, quote, lives were lost, blood was shed, portions of the Capitol building were badly damaged, and lives of members of Congress were endangered. So then why didn't you indict him for that? Hello? Just charge him for insurrection then, Jack. If all this is true, if lives were lost, right? Like Ashley Babbitt, who was shot and killed. Blood was shed, like when the police were shooting down from the rooftops, blowing holes in people's cheeks, as we heard from testimony in the Proud Boys trial. Shoot, boom, 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 just shooting off at people before there was any need to, right? Instigating the whole scene. Very curious. So they say the district court has scheduled trial to begin March 4th, one day before Super Tuesday. Jury questionnaires go out February 9th, so we start getting some jurors in. They say that in all of this, the court has scheduled a trial date for this time, even though Trump wanted it April 2026. And they say, we've held several hearings on this Court of Appeals. Jack Smith argues, at a hearing shortly after Trump's indictment, the district court, through Judge Chutkan, noted that the court was, quote, committed to ensuring this case proceeds in the normal course that our criminal justice system prescribes. Now, to that end, court explained that although the defendant would be afforded all the rights, the court was also cognizant of the efforts to prevent a carnival atmosphere of unchecked publicity, and said that the court issued a general word of caution. But even after these admonitions, Trump has persistently used social media. This is Jack Smith, government prosecutors, whining about Trump's Truth Social posts like little babies, to make prejudicial comments about the case and its participants. 3 days after the indictment, Trump issued a public threat, says Jack. If you go after me, I'm coming after you, which I absolutely endorse, by the way. It's like, hello? What are you kidding? If you think you can just launch political prosecutions on one side in this country and not expect the pendulum to swing the other way, like, that's why we didn't start criminal prosecutions in this country for 234 years. We just said, it's not worth it, man, because it's Banana Republic stuff, because this is what happens, obviously. And if Trump did it, okay, if Trump actually did indict Hillary, well, we would all be sitting here going, well, of course he's going to be indicted. What do you think's going to happen? Hello? Here's why he didn't. But the Democrats broke glass in case of emergency. They cannot have Trump win again. And, you know, that'd be the end of them. So they're coming after him. So of course he should come after them. Okay, that's called politics. And if you're going to weaponize the judicial system, the person who captures the flag of the judicial system makes the rules. Sorry, man. And so now they want to shut him up for even bringing that up. So they followed through on that threat, he used disparaging and inflammatory language to target the district court, the special counsel and the deranged thugs there, and trial witnesses, as he knew from discovery that we're expected to offer inculpatory testimony against him. They were going to incriminate him. So Trump described a pending district court judge as a fraud and a hack, Judge Chutkan. He repeatedly called the prosecutors in the case deranged, which, called them thugs, called them lunatics, and asserted that one of them, whom he identified by name, had gone to the White House for an improper purpose, a claim that he knew to be false from the materials that he had reviewed in discovery, probably talking about Jay Bratt. He described his former vice president, Mike Pence, as delusional, not a very good person, who wants to show he's a tough guy, which is all he was running against him in the presidency. He said the former vice president made up stories, and Trump should not be allowed to say, like, do you see where this is going? He should not be allowed to talk about this stuff. He said that the person that he appointed chairman of the Joint Chiefs of Staff, Mark Milley, white rage guy, another foreseeable trial witness, had done something so egregious that he should be punished accordingly. He said the potentially unfavorable testimony was a lie, and he made all these statements, and all of these statements were amplified by social media users, including his followers, gross MAGA people, who he has boasted listened to him like no one else, and then widely reported on in the national media. So Trump has a community, man. Trump has a group of people, a movement, who are going to support him, and they don't like that at all. 4 days after the indictment, he said, if you go after me, I'm coming after you. One of his followers called the district court and said, hey, you stupid bad word, if Trump doesn't get elected, we're coming to eliminate you. So tread lightly. You'll be targeted and your family, all of it. Okay, so this is an illegal statement. You see this here? This is wild. So they're actually even referencing the case. This is a criminal complaint. Okay, so by the way, if you call a judge and leave a statement like this, hey, we're coming to remove you, judge, that's a crime. And they take it very seriously. You cannot do anything like this to anybody in the government at all. Don't even joke about it. Joe Biden was posting on his X account, hey, text me. Just text me how you think I'm doing. I'm like, do not text him. Okay, you'll have the feds show up at your doorstep. So this person called, they made a bad comment, probably somebody who's not very well, and here is what we see. They got charged with a crime. The case is called United States versus Schride, and and they may have been under the influence. I don't know what happened. They got charged, is my point. Like, there is recourse for this. That episode, they say, was part of a pattern stretching back years, and so they really dug in. They're like, judge, do you have any bad phone calls? Like anything? I don't know. She's like, no, I mean, most things are just like, this is my housekeeper, this is my girl's school. No, no bad messages. Okay, I think we have one. And they dug one up. But this is a pattern. Say an election commissioner who was targeted by Trump in the aftermath of 2020. So now we go all the way back. So the one complaint, this guy got charged with a crime back in August, Southern District of Texas, he called from. Now, after the president tweeted at this person in 2020, oh man, there were some threats. They became much more graphic and they came in to me. Again, illegal. An election worker also testified when someone as powerful as Trump eggs on a mob, and a state judge also said that some people need additional protection. So since the presiding judge there ordered the removal of the post, oh my gosh, this is the New York case. Ah, gosh. All right, so I told you, man, we've seen this, okay? They are just playing off the judges. So Jack Smith goes over to Judge Engeron, who's an elected Democrat, whose court clerk, law clerk, called Allison Greenfield, has a history of making thousands of dollars of donations to Democrats, who has been passing him, I don't know what kind of love notes. The thing has been so corrupt that the judge has gagged the defense attorneys from even commenting on their little massage sessions in the middle of the trial. And so now Jack Smith is referencing that in the Chutkan case in the Court of Appeals. Let's make sure we're right about this. He said, so what happened was there was a tweet, a state judge, probably Engeron, likewise described needing additional police protection after the defendant targeted him on social media. More recently, the defendant, Trump, posted a social media photograph of a state judge's law clerk. Oh, it's his Greenfield, along with the caption falsely alleging that she was the girlfriend of a political adversary like Chuck Schumer. Now, the presiding judge there ordered the removal of the post, but has stated, this is Engeron, since the commencement of this bench trial, my chambers have been inundated with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages, all of which, okay, if they're actually threatening, are prosecutable. And the feds take it very seriously. They'll prosecute it, and they go find the people. Easy. It's very easy. Where'd you call from? Where'd the phone call come from? They show up. You're under arrest, threatening a federal judge or a state judge. Doesn't play well. So why don't they report all of these things, okay? Or are they just people saying, hey, what you're doing is, not appropriate. I'm articulating my disdain for you as a citizen citizen of your jurisdiction. Now, as alleged in the indictment, Jack Smith says, Trump seeks to use this well-known dynamic to his advantage. It's called free speech. Hello. It's the First Amendment for a reason. It's so when there are tyrannical endeavors like the one you're on, Jack, that somebody can speak out about it and galvanize the public to their side. And by the way, if Trump is wrong, if the public is against him, then he has no tools. They'll just listen to his free speech. They'll say he's whacked and he'll lose. So you will not need to gag him. But the problem is he's right and you're wrong, which is why you got to silence him. They say he's using this like he did with Mike Pence. He said that he alerted the Secret Service detail. He says he targeted Mike Pence, and we knew this was going to be the narrative again, okay? Trump used social media to insurrect on January 6th, and Trump is going to use social media to insurrect again. That's going to be the narrative. Trump has done this for a long time. He's recently described this dynamic. He says it's continued unabated in this case and other cases involving Trump for years. And they give us some background here, okay? Now they're going to be explaining why the gag order is so appropriate. They say in 1966, the Judicial Conference studied a lot of this stuff, and they created a bunch of rules for us. Now, they did 2 years of deliberation and research, and they came up with some rules. In 1980, they released a revised report, and the U.S. District Court has adopted a local rule that mirrors the language that was proposed by the committee, okay? So Judge Chutkan and her district court, they've adopted this local rule based on all of that other stuff. And the local rule is close. It says, in a widely publicized or sensational criminal case, a court may, among other things, issue a special order governing the matters like extrajudicial statements by the parties that are likely to interfere with the rights of the accused to a fair trial by an impartial jury. Isn't that interesting? So Trump's statements, it looks like this rule is crafted for the rights of the accused. Well, what if Trump wants to waive that? Okay, he thinks his free speech is going to support his rights, not harm his rights. The gag is interfering with his rights, not otherwise. But on September 15th, the government filed on the public docket a gag order. Trump obviously opposed the gag order. And at the hearing, the district court reviewed a bunch of Trump's statements and made her rulings. And she said that there are incidents that have led people to be harassed and threatened. The district court asked the defense about the purpose behind his labels, and she says it risks a real possibility of violence for calling people thugs and calling them deranged. I guess he should only call them legal scholars. The legal scholars at the DOJ are prosecuting me in a manner that I find slightly offensive, but otherwise morally acceptable because I can't say otherwise, because I'm a polite person and free speech is not really free or something. What are you talking about? It's called free speech. In his view, they say, well, Trump made some comments about Milley and others. Now, the court orally granted the government's motion, said, yes, I need to silence Trump to administer justice, and then issued the gag order. In its written order, the court reiterated that we have to safeguard these proceedings, and that undisputed evidence is that Trump has publicly attacked individuals, and those people are then subsequently harassed. The judge found that witnesses will be intimidated, and we don't want people becoming threats of harassment and so on. Now, we're getting through some of the history, so let's fast forward and see what the argument says. They say the district court order, Court of Appeals, should be affirmed. There has never been a criminal case in which a court has granted a defendant an unfettered right to try his case in the media. Do you see how they flip this? Wild. So Trump's defense said there has never been a case where a criminal defendant has been gagged like this. Never. And they say, oh yeah? Well, there's never been a right where a defendant has been granted the right to say whatever he wants, where he can malign the prosecutor and his family, and after threatening a witness, he can say, if you go after me, I'm coming after you. They really don't like that line because they know they're first on the chopping block, you know, from being fired from government. Says target specific witnesses with attacks on their character and credibility, calling one a weakling. They are weaklings. Calling them cowards. They are cowards. They are. They're trying to gag him and do all this stuff without cameras in the dark of night. Suggesting that another actions warrants punishment. Well, treason carries certain punishments. The defendant, nevertheless, Trump, claims that the First Amendment grants him unfettered right to do these things and more. It absolutely does. That's absolutely true. He insists that the district court is powerless to prevent him from posting photographs of court personnel. Why should they be? Or publicly, is it illegal? Or publicly telling known witnesses that they should learn to keep their mouth shut. Now, he's in the middle of a political campaign. He's allowed to talk about politics. The fact that you're prosecuting him for a crime that is a political crime is your problem. Doesn't mean that he suddenly negates his free speech defense to these political charges. The demonstrable likelihood that such targeted attacks will result in threats, harassment, and intimidation, in the defendant's view, is totally irrelevant. It is, because Trump's free speech is a separate issue. If those people are harassed by other people who are not Trump, by the way, if Trump commits harassment, if Trump commits intimidation, that's a new crime. time. If any one of his posts amounts to legal intimidation or legal harassment or constitutes a legal threat, charge him, Jack, just like they charged this other guy up above. He called and made an actual threat to the judge. They arrested him. If Trump does something that constitutes an actual threat, then charge him. Otherwise, it's free speech. The most a district court can do, he maintains, is accede to his repeated request to delay the trial, ask the counsel to delay the admonitions, and hope that he abides by them. But the First Amendment, says Jack Smith, does not require the court to adopt such an ineffectual approach to protecting the integrity and the fairness of criminal proceedings. To the contrary, district courts have an affirmative duty to prevent trial participants, including attorneys and defendants, from engaging in extrajudicial speech that poses a substantial likelihood to materially prejudice the proceedings. The district court entered the order correctly here. The order was based, Court of Appeals, on well-supported findings, narrowly tailored, right? So meaning it's not unconstitutional. And by the way, there's two constitutional layers here: Trump's right to speak and our right to receive. What good is speaking if there's nobody listening? And more sufficiently clear to provide with Trump with fair notice of conduct that he must abide by. The order leaves Trump to do virtually everything that he's claimed he's able to do, including even describing the prosecution as being politically motivated. And so they say, Your Honors, this order should be affirmed. And briefly, we'll hit some of the highlights. They say the district court issued an appropriate order, and you should be deferential to them. They're allowed to use the local rules to govern their courtrooms. A lot of case here, okay? So you can see we're fast forwarding through all the parentheticals, all the italics, all the cases. They're just copy and pasting all the case law, blah, blah, blah. Despite being a trial participant, they say that the clear and present danger test applies, meaning Trump's free speech is still protected unless it meets that standard. And they're saying, no, this rule supersedes that, and defendants are regularly subject to liberty restrictions, right? They're under indictment. So we are used to restricting their liberties, and free speech is one of those that we can impose. A court may impose these restrictions simply because he's a party to an indictment. The court gets jurisdiction and supervision. So they say that the court has the right to do this. The district court had the authority to issue this order, and it satisfies this standard. It was appropriate and it was necessary. Otherwise, we're not going to have a fair trial. First, Trump has a long history of using his social media accounts to target perceived adversaries and singling them out. Second, when he does that, intimidation reliably follows. Then those harassments brought by those other third parties pose a significant and immediate risk that the witnesses will be intimidated or otherwise unduly influenced or will become targets of threats and harassment themselves. You know, all speculative based on Trump's statements, and they are trying to muzzle him now. They say Trump does not meaningfully dispute the accuracy of these findings, which were not erroneous, and so the lower level court should be affirmed. They say the court findings were inadequate because they weren't based on affidavits or live testimony, but they say, no, we've seen enough in the pattern. He's just done it long enough. Here, they drag this quote out again. If you go after me, I'm coming after you, which is part of the reason, we're going to vote for him here. But because the district court's order was directed at preventing material prejudice, the court properly focused on the effect of the conduct, and there is an exception to the first rather than on the exception to the First Amendment. So the judge is just saying, look, it's my courtroom. I got to protect my courtroom, and the same principle applies here at the Court of Appeals level. They say the order is narrowly tailored, so it's far narrower. Okay, so Trump actually, we're giving him plenty of speech. Look at these other cases that say we can do this. The order here is even narrower than those. They just say that it's about the case, but he can still talk about the political prosecution that's taking place here. And as we wrap up through the rest of this, let's see what they're ultimately asking for. This is a lot of the case law is being dumped here, and we'll fast forward to the conclusion. A lot of case law here. You can see Jack Smith, Molly Gaston signed off on it, and they bring us to a close. They say courts have rejected vagueness challenges to other even less clear orders. One of the arguments that Trump made is that I don't even know what this order means, all right? It says like no reasonably foreseeable witness. That could be anybody. And so it's so vague, I can't even tell what it involves. And they say this has all been rejected previously. And so the court should also reject Trump's vagueness challenge here. And for the foregoing reasons, the court should affirm Judge Chutkan's gag order signed by Jack Smith, Molly Gaston, and the rest of the deranged thug prosecutors over there at the DOJ going into the DC Court of Appeals. And so this is something that we'll continue to follow. Of course, we'll have oral arguments scheduled back on November 20th, 2023. I do believe that they might even be audio streamed. So we'll clip from there and cover exactly what happened. So my friends, thank you for subscribing. doing on this channel. We're covering all the Trump cases. We'll be doing so indefinitely. And so we hope that you join us. We'd also love it if you checked out robertgovea.com and sign up for our daily newsletter. And that way we can stay connected as this case and others unfold. And so we do have one final clip here. Now, Speaker Johnson was asked about this because he's being asked about Trump being under indictment and what his take is. And he says, I think Trump is really in alignment with the rule of law. He did some good work on the Supreme Court judges, and all of these efforts and all of his statements are, acceptable. And he's not trying to instigate harassment. He's trying to speak out against the political prosecutions that are taking place against him. Here is the new speaker.
I know that he has been absolutely consistent from day one, and he does believe in the rule of law. I mean, look at what he did on the U.S. Supreme Court, for example. He's gave us great justices that are restoring the integrity of that institution, in my view. We had, of course, many judges throughout the system that he appointed, and that's the longest-lasting legacy of any
Speaker,
president.
you're talking about the rule
so
of
he has
law.
A good record.
You're talking about the rule of law, and he's now been indicted, on 40 different charges. There's such a juxtaposition behind the idea of rule of law and then things that he's done that may very well have broken the law. And I recognize that there's elements of it that may be political. I'm not even going to dismiss that.
They're political.
But I'll stipulate with you that there are elements that are probably true that are political, but not all of them.
Yeah, all of them.
Listen,
yes.
I think this is motivated by political prosecutions, and we call it lawfare. That's what it is. It's just another way to go after a candidate. And what's happened to President Trump is unprecedented.
True.
And every time a new indictment drops, it follows after some favorable thing that he gets in a poll or an election or whatever.
Always happens. Maybe they'll indict him again because they keep losing. So, of course, my friends, we'll be here continuing to cover. Thank you for subscribing and joining us at robertgovea.com, and we'll look forward to seeing you on the next one.